Good day to you and welcome to another Paddocks Club video tutorial. Today I want to talk to you about the question of recording scheme meetings and examine the question of whether or not this is legal. The background to this video tutorial is a question that Marge Mitchell asked on the discussion forum, and her question was, is it lawful to record the proceedings of an SGM or an AGM? David Nohati jumped in and said, well, I don't know if it's legal, but I've been doing this for about 40 years. I've never asked permission to do so. I do it openly. I switch on my recorder, place it on the table where it's visible. I've never been challenged. And some people, like he, will do it openly. But we also know that most people have cell phones capable of voice recording, and many do this secretly. So the issue, again, is it legal? The first question is, of course, whether there's any legislation applicable to this particular issue. And the legislation often quoted in this regard is the Regulation of Interception of Communications and Provision of Communication-Related Information Act of 2002, which is usually referred to as RICA. It's aimed at preventing a person intercepting by any means, for example, eavesdropping, hacking into or wiretapping, any communication sent by any medium whatsoever, including speech. Its starting position is that no person who is not a participant in a communication may intentionally intercept that communication in the course of its occurrence or transmission. But Section 4 of RICA states that any person may intercept any communication if he or she is a party to the communication, unless he does or she does so for the purpose of committing an offence. So while the recording of an eavesdropped conversation in which you are not participating is unlawful under RICA, recording a conversation or the words spoken at a meeting you are having with another person or a meeting you are having with a group of people without them knowing that you're doing that recording is not unlawful, at least under RICA. So the second question to be asked is whether or not the recording, secret, let's say, but let's say it might be public, it might be open, whether it infringes any constitutional right that a person may have. Well, this depends on whether the people involved have a reasonable expectation of privacy in the context of that particular conversation or meeting. In the leading case in this issue, which was a criminal case, the defendant tried to have a tape-recorded confession of a murder excluded on the basis that it infringed his right to privacy under the Constitution. The judge looked at the thing quite deeply and gave categories of relationship that would in fact give rise to the expectation of privacy. So spouses or life partners, persons in a counseling or therapeutic relationship, such as a psychologist or a lawyer, a patient receiving administration or psychological or pastoral or religious support. So an example would be a doctor or a priest giving somebody assistance. People in a legal or contractual relationship that requires confidentiality. All of those people are entitled to expect confidentiality. But a sectional title meeting of trustees or of owners is not one which you can expect to be confidential unless the rules of your particular scheme impose an obligation on the owners and trustees to keep proceedings confidential, which I think is very unusual if it exists at all. In the absence of such a rule giving rise to a reasonable expectation of privacy, what you say can be repeated to third parties, and it can be published, even reported in the press. So the takeaway lesson from this video tutorial is use the Sunday Times test. In other words, if you'd be embarrassed by by the national publication of what you want to say, then don't say it, except to someone who you can reasonably expect will keep it confidential. Thank you for joining me. If you have any questions, let's deal with them in the discussion forum.